Get going. Okay, let's get on the record. This is case 18 SC 159981. It's State versus Megan Goodfellow. I see Ms. Goodfellow on the Zoom session. Are you dialing in from Texas? You're on mute, Ms. Goodfellow, which is okay, but
Yeah, yes, I am, sir.
where in Texas?
Montgomery, Texas, which is about 70 miles north of Houston.
Okay, great. Well, thanks for joining us. Ms. Goodfellow is represented by Mr. Hawkins. Good morning, Mr. Hawkins.
Good morning, Judge.
And then Mr. Pinion, you're handling this matter. I don't know if it was your case when the plea was taken. I know Mr. Hawkins has had this throughout. He represented Ms. Goodfellow for the plea. It was a plea taken in front of Judge Reeder, not myself. So I know not a whole lot about it. Was it your case back then, Mr. Pinion?
It was not my case.
Okay. But I'm sure you've learned more about it. And then we have a victim in the matter, Ms. Jackson, who was struck by a vehicle that Ms. Goodfellow was driving in Roswell. Ms. Rolak, is Ms. Jackson joining us? There she is. Okay. Good morning, Ms. Jackson.
Good morning. Mr. Jackson is also here with me.
That's fine. Hello, Mr. Jackson.
Good morning, sir.
I hope he's being socially distant from you, Ms. Jackson.
There's two.
All right. Well, let me tell you what I understand we're here for. Mr. Hawkins has filed on behalf of Ms. Goodfellow a motion to terminate her probation early. And he's explained why, and I'll let him do so again here on the record in front of everyone. The sentence that Ms. Goodfellow received was a 5-year probated sentence pursuant to first offender. It was 5 years on counts 1 and 2. Count 3 merged into count 1. It was a total of 5 years probation. And that sentence was entered. I don't have the signature line that I printed out. It was, it looks like April of 2019. So not quite 2 years ago. And that's what Ms. Goodfellow is seeking to do through this pleading. I guess before I require Mr. Hawkins to present everything that he wants to, Mr. Pinion, is this something that the state is opposing, takes no position on, or is supporting?
Your Honor, the state opposes the early termination.
Okay. And is that opposition based in part on input from Ms. Jackson?
Yes, Your Honor, Ms. Jackson and Mr. Jackson were both injured.
Oh, both. Okay. I'm not trying to exclude Mr. Jackson from this. Oh, look at that. So count 2. It's 2 counts of serious injury by vehicle. Ronald Jackson and Elizabeth Jackson. It's good they're both here. Okay. Well, then we will want to give everyone a full hearing on this. I was just going to streamline it depending on what people's perspectives were. So, Mr. Hawkins, why don't you get us started? I did read what you called the statement of facts that details that Ms. Goodfellow has already taken care of her community service, not over 5 years, but within 15 months. And that in her assessment and yours, she ought to have her probation terminated early. So talk to me about that. And then, of course, I will give Mr. Pinion and the Jacksons a full hearing as well.
Thank you, Your Honor. The first thing that I'll say that when Ms. Goodfellow called me to ask me about filing this motion, she reminded me, and I believe it's on the record, Judge. I'm not 100% sure because I did not get a transcript of it. There actually was a discussion in court about early termination. And let me share with you where that arose from. This was a case, Your Honor, no alcohol, no drugs, nothing like that involved. There was a video of Miss Goodfellow turning left during a festival in Roswell. Lots of pedestrian traffic on the street. She looked left and saw that the people were not walking yet, and so she made her turn, and she failed to look to her right where people would have been coming towards her, and Mr. and Mrs. Jackson were stepping into the roadway. She accepted responsibility outright, was very remorseful throughout the proceedings and at the hearing. The single thing that I remember that struck me about the sentencing hearing, frankly, Judge, is how gracious Mr. and Mrs. Jackson were about the situation. They were both injured. This was a situation where initially the state was asking for prison time, and Mr. and Mrs. Jackson basically at the podium said that that was not their wish, that they wanted something good to come out of this. What we ended up doing, Your Honor, with Judge Reeder, and if you look at the sentence, I'm afraid the sentence documents are not numbered, but at the top of the second to last page, the page right before the judge's signature and the defendant's signature, you'll see at the top, it states that the defendant must pay an amount of fines of $1,500 and to perform 500 hours of community service. One of the beneficial things I think that came out of this case is that there was a discussion about what Mr. and Mrs. Jackson felt appropriate community service should be in this case. And I believe they worked with probation or with someone from the district attorney's office to communicate where we would designate she would do the 500 hours of community service over a 5-year period. And you'll see in the sentence, it's 100 hours per year at one of the following 4 programs: Girls Empowerment Network, Ways to Give, Texas Children's Hospital, Houston Area Women's Center, or Barbara Bush Houston Literacy Foundation. Obviously, as you can see, Miss Goodfellow lives near Houston, as she mentioned before. But this was a sentencing hearing, frankly, Judge, you've done many of these, that was less contested about what took place and more about what the appropriate sanctions would be. And so I walked away from this hearing just overwhelmingly, and Miss Goodfellow being overwhelmingly grateful for the input of Mr. and Mrs. Jackson. There was mention at the hearing that Miss Goodfellow intended to try and accomplish all of the sanctions that she was given by Judge Reeder sooner rather than later. If you see, we attached all of the paperwork to our motion, Your Honor. She has been what her probation supervisor described as a model probationer. She completed the 500 hours of community service in 15 months' time. And Judge, if you just do a little bit of math, you'll see that that works out to between 8 and 9 hours each week for 15 months. So it's almost as if she embraced this sentence and the community service part of it as a second job. And I want to talk about that in just a moment, about why one of the things that the reasons that we're asking the court to consider this. She has paid all of her fines early. She's done all of her community service early. She has reported every time as required. Judge, she had no significant criminal history prior to this. She works, Your Honor, as the chief credit officer.
Mr. Hawkins, let me stop you for a sec. You used the word significant. So you said Ms. Goodfellow had no significant criminal history. What criminal history did she have that you deem insignificant?
No arrest, Judge, just traffic violations, minor traffic violations. And Ms. Goodfellow, if you want to speak to that, I don't have your history in front of me. My memory is that there's nothing there, Judge, but I don't like to say she has no history, because then someone will come and say, well, she had this speeding ticket or this, that, or the other. My memory is that she had nothing but minor traffic violations. Is that accurate, Ms. Goodfellow, if I may?
Yes, I had a rolling through a stop sign in a subdivision near our home in Roswell, and I had a speeding ticket in the city of Atlanta.
Okay, thank you.
That's it.
Yes, just out of an abundance of caution, just wanting to be accurate, Judge, she really has nothing but minor traffic violations, both of which were taken care of. May I continue, Your Honor?
Please.
She is the chief credit officer for balance sheet lending for a company called Oryx Real Estate Capital. Judge, in that capacity, she is required to submit annual SEC and quarterly compliance statements. She's fully disclosed this matter to her employer, and they have retained her on. But with the SEC reporting, she does feel, particularly during the pandemic, that her employment is somewhat at risk. She is required annually to report that she is under a probated sentence in the Superior Court of Fulton County, state of Georgia. She's worked very diligently over her career. Judge, this is a very high-level position. She is the primary source of income for her family, and she would like to resolve this issue to essentially alleviate any notion that it may give her employer pause about the situation, given what's happening in the economy and in the pandemic. I certainly understand that the state is opposed to that. You know, oftentimes in this situation where the sentence was imposed for 5 years, that is their role in this. But when you consider what the statutory law in the state of Georgia states, and if I may just identify that, Judge, if you will look at 1710(1) and 42-8-34, the trial court has the authority to change or modify a probated sentence if it, quote, determines that probation is no longer necessary or appropriate for the ends of justice, the protection of society, and the rehabilitation of the defendant. Given that Ms. Goodfellow has committed to not just expediting it, but I don't mind sharing this with you, Judge. I've never seen a defendant complete this amount of community service in this short amount of time and do it in a manner that seeks to honor the injuries that she caused to Mr. and Mrs. Jackson. And I guess, like I said before, with at least the court asking for some of their input on causes that were important to them for her to accomplish these things. She remains, Judge, in my conversations with her, very remorseful about this. And so I think this is a case where if you go back and look at the sentencing hearing itself, if you look at the extraordinary manner in which Ms. Goodfellow has sought to pay her debt to society, to accomplish the terms and conditions of her sentence in an expedited manner, all the time while supporting her family, working full time, doing community service at the rapid pace that she did, paying all of her fines in advance. I would ask the court to look at this situation and say, perhaps there is not a better case that I have seen for the court to consider early termination of the sentence. And if the court wishes to inquire of Ms. Goodfellow, Your Honor, she has stated to me that she's certainly willing to answer the court's questions or to speak to the court if the court finds that necessary.
Okay.
Certainly would invite the court, if the court is so inclined, to inquire of Mr. and Mrs. Jackson as well. I'm sure you intend to do that.
I do. I have a question for you, Mr. Hawkins. The final disposition indicates that it was non-negotiated, and you've let me know that whoever the prosecutor was at the time actually initially was seeking a period of custody for Ms. Goodfellow. That's not how it played out, but it does say that the plea was non-negotiated. What sentence did you ask for on behalf of your client?
Judge, we asked for probation. We did not specify fines or community service. After the court, and forgive me, Mr. and Mrs. Jackson, if I misstate anything, it's not my intention to do so. My recollection is they spoke on her behalf, recognized that this was not done intentionally, but was done sort of carelessly. You know, there was no alcohol, there was no drugs. They advocated against any kind of incarceration sentence. And frankly, Judge, this was a plea that was sort of hashed out with Judge Reeder. I want to say that the ADA was Miss Love. I could be wrong on that.
That makes sense.
I think that's right. And she gave the Jacksons the opportunity to address the court, and Judge Reeder sort of from the bench inquired of them what is it that you think is a fair outcome here, and ultimately Ms. Goodfellow was saddled, like as you know, with a significant amount of community service. But my memory is that input was requested from the Jacksons on where they thought appropriate community service would be done, and that's what we ended up with, Judge.
Did you, Mr. Hawkins, ask for a specific period of probation, or were you simply saying anything but prison? It can be probation, it could be whatever, or did you say we think it should be X years of probation?
Yeah, so in fairness, Judge, I was second chair on this with an attorney named AJ Richmond. I've handled a fair amount of these cases, for better or for worse, at sentencing hearings, and Mr. Richmond brought me in to consult with him. I met with Miss Goodfellow, and so I don't want to describe this as an 11th hour add-on for me, but I came into the case very late. Once the decision was made that Miss Goodfellow did not want to take the case to trial. Miss Goodfellow wanted to accept responsibility, and I was essentially brought in to do my best to try and negotiate the most fair outcome for Miss Goodfellow. So forgive me, I don't believe, Judge, my answer is this: I don't believe we asked for a specific term. I did notice, Your Honor, I wanted to mention on the second to last page that I mentioned, there is reference to 1710(1)(a)(1)(b). Are you familiar with that provision, Your Honor, or this is sort of a boilerplate sort of lands in these sentences, but it describes that within 60 days of the expiration of defendant's behavioral incentive date, certain steps were to be taken by the Department of Community Supervision. I don't think perhaps that was thought through well, because what the sentence was 100 hours of community service each year for 5 years. Miss Goodfellow's ability to accomplish that by April 8th, 2020 would have been even more extraordinary than she had done, and perhaps impossible given that she's working full time. So there is at least a provision I see in the sentence, Judge, for the court to consider early termination.
Yeah, I see that. That is not, I am familiar with the statute. It was a semi-recent amendment to 1710(1). That language infrequently makes it into final dispositions. I assumed it was there because you asked for it to be put there, but if that's something that Judge Reeder was doing as a matter of course, I haven't seen it many times since I have taken over her docket, but I'm familiar with the concept of the behavioral incentive date. We don't see them come up very often.
Yeah.
I think legislatively it was a great idea, but practically it has seldom been pursued, but it's certainly something out there. Yeah. I do have a couple questions for Ms. Goodfellow that may spawn others, but let me ask you a few questions, Ms. Goodfellow. First, Mr. Hawkins helped me understand some of the work you do. Tell me in more layperson's terms, what does your company do?
We are a commercial real estate lender focused in the multifamily affordable housing space. And I serve as the credit officer reviewing submissions and final requests for loans on these properties, and it's a nationwide platform.
So if I own an apartment complex and I need to borrow money, I might use your company, or I want to buy an apartment complex, I might use your company to help get funding.
Correct. We have two branches. One deals with the government-sponsored agencies, as you know them, Fannie and Freddie. And the part of the company I work on is balance sheet, which is really meant to be a feeder for the Fannie Freddie product. So yes, that if you were buying an apartment, you may very well come through our company.
How long have you, it's called Oryx, Oryx?
Oryx Real Estate Capital. Oryx actually acquired my predecessor employer, which was Hunt Real Estate Capital. Same, they acquired it last year. Same platform. And I've been at Hunt since 2016. I had previously been at the same firm from 2007 to 2014 and took a couple years to work on a fintech startup out that didn't go so well.
Okay, but you made it back to Hunt. So when you entered your plea in this case, were you aware that you would need to report your status as a probationer to the SEC?
Yes, I talked to our compliance officer, our chief compliance officer, provided her the court documents, and because and please forgive me, I'm not a lawyer, because it said it was a deferred judgment pending under the first offender statute, that since there was a possibility that I could successfully complete this and satisfy the requirements, and within the 2 years that we read in the document, they have allowed me to continue my employment with the understanding that I adhere to all the provisions and have no setbacks or violations.
Right. You currently do not have a conviction. You are a first offender probationer. So it is a distinction with an important meaning. You don't have to check any box that says you're a felon. And I have no doubt you will successfully complete your probation, whether I decide you have already done so or I decide that you have a little ways to go.
I apologize for running, but the SEC form, and it's a FINRA form as well, requires you to disclose also if you have been charged with.
Sure.
I think so. And I like to be very forthcoming in those filings.
That's a good policy. I think that will help you out. But what you're telling me then, if I'm understanding this correctly, is that you knew that you would need to make these disclosures before you entered your plea, correct?
Correct.
Okay. Share with me what adverse consequences, if any, you have encountered from the SEC or through your work because you've had to make these disclosures. Other than, I did hear Mr. Hawkins, there's certainly the unease, the uncertainty of, well, might someone say, it's great that we've got Ms. Goodfellow, but she's got this baggage. She's got to make these disclosures each year. That makes us uncomfortable. We'd rather have Jenny Jones do this work instead because she doesn't need to make those disclosures. So I appreciate there's that unease, but beyond that, share with me what adverse consequences there have been, if any, because you've had to make these disclosures.
Well, the concern really has been escalating over the course of the year as our business has been severely contracted due to COVID. Obviously, we're commercial real estate and transactions are very low. And looming, the company's been, cautious about, not laying people off, but our fiscal year is March 31st. And I am concerned that if there is a layoff, to your point, I am a person with baggage, and there are, comparable people at the firm if they choose to merge some functions.
Okay, but none of the diminution in business is attributable to your status. It's attributable to the economic impact of the pandemic.
Correct, sir.
Okay, all right. Mr. Hawkins also mentioned that you are the primary provider for your household. Tell me what household means. Who else who are your dependents?
My husband is a retired Houston police officer. He currently works part-time at TSA. We support our son, who is a disabled military veteran. He's currently attending university up at SMU, and we are helping support those efforts.
Okay, well, thank you for his service. I hope he's doing okay.
Well,
And
thank you.
your husband retired from Houston PD and is now, you said, working part-time.
Correct.
But it was a voluntary retirement. He reached an age where he could get a nice pension or this or that, or what happened?
He retired in 1998 when my career began escalating. At that point in time, I worked at JP Morgan, and he retired in order to take care of our two children.
Okay. I think that's it for right now. Let me ask Mr. Pinion a few questions and hear from him. And then certainly I want to hear from the Jacksons if there's anything that they want to add. And then Mr. Hawkins, you as the movement can have the last word if there are any things you want to share to clear things up. Mr. Pinion, I know you weren't the lawyer who was originally representing the state, so the questions I have may be a little tricky for you to answer. But I guess I'm trying to understand why this is a case which sounds to me more like a very unfortunate accident, not one based on intent. I'm not hearing that Ms. Goodfellow was drinking or driving 80 miles an hour when she made the turn. She wasn't careful. She didn't look to her right, and that had some real serious consequences. But those kinds of things happen all the time, and what doesn't happen is that they end up in criminal court. They end up in civil court. There's a lawsuit, insurance, people sue. So I'm trying to understand, I guess it's twofold. Why was this a criminal case? And second, why would the DA's office been seeking prison time for what is arguably a matter of negligence? At least as it appears to me. Again, I know none of the facts, but you are in the enviable position of needing to help me understand how this ended up on Judge Reeder's docket to begin with.
Well, Your Honor, I did read the discovery package, and I spoke to one of our indictment writers who had worked on the case. So I do have some knowledge into that. Your Honor, my understanding is that, and the Mr. and Ms. Jackson could tell you for sure that there was a street festival going on, and that there were numerous pedestrians, and so traffic had been backed up. It wasn't a case where a pedestrian came out of nowhere. I believe even Ms. Goodfellow said she'd been at the light for about 10 minutes because it was difficult to turn left. There was a video of the accident. Ms. Goodfellow had initially told the police that the sun got in her eyes and she did not see the pedestrians entering the roadway, but that seemed to be contradicted by the video, which showed that there were clearly people waiting to cross the street. The pedestrians did have the right of way clearly from the video. They had a sign saying they were clear to walk, and that you could see Ms. Goodfellow's vehicle not brake, but speed up and seem to beat the people that were starting to enter the intersection. So it wasn't a negligence, but a calculated risk that she could make the turn before the pedestrians stepped out into the roadway, which was not the case. The victims, Mr. and Ms. Jackson, were very seriously injured. I did speak to Ms. Jackson, and I've also looked at the photos of their injuries, and I believe Ms. Jackson was trapped under her car.
Well, and I want to be real clear to everyone involved. My observation is not that this was not serious. People die in situations like this. So it's not a question of the gravity. I'm just trying to, and this may help the Jacksons understand the origin of my question. I see criminal cases of all sorts with dead bodies and surviving bodies, et cetera. But usually serious injury by vehicle is accompanied with a DUI, or I appreciate there's a reckless driving count in this. And this is what Mr. Pinion's helping me understand. But we need to be very thoughtful before we criminalize negligent behavior, because you could be doing all the right things on the road and you just forgot to look over your left shoulder when you did something, and tragedy follows. And that doesn't make anything less tragic, but we try not to make a criminal out of a person who made a mistake. And that's the only reason why I'm asking these questions. I'm not trying to undo the plea. It was a plea, and Ms. Goodfellow went in with eyes wide open. Frankly, she asked for probation and got it. I'm all right with that. I'm just trying to understand sort of the genesis of this, and this is helpful. So it was in no way to suggest, gosh, this doesn't seem important, it doesn't seem serious. It's all those things, but it's giving me some context, in particular, helping understand what Mr. Hawkins observed, which was that Ms. Love was originally advocating for prison time, which we get in serious injury by vehicle cases. But just again, to give everyone some context, that's typically someone was so drunk he got on the freeway going the wrong way and hurt someone. I think that's easier for folks to understand. You may need to go to jail for doing something like this. This sounds like it's in a slightly different category, not because the injuries were less serious or anything like that, but I'm appreciating the information I'm getting from Mr. Pinion. So back to you, Mr. Pinion.
Okay. And so the decision was made that this appeared to be to have a more intent than just mere negligence. As to something that I wanted to address, it, she did admit that she had drank a small amount of alcohol. The field, I don't know exactly what you call it, breath test, came back a 0.039. There were field tests. She passed a number of them and failed a few. And the officer decided that the level of alcohol was not to a level that he felt that it affected her driving, so he did not charge her with.
But it would be wrong to say there was nothing in Ms. Goodfellow's system.
Correct. And
okay.
That's why I thought to mention that. So I did see, just from looking in Odyssey, that Ms. Love did file a state recommendation of 5 to do 3 2 days before the recommendation. I don't have access to the sentence, the plea colloquy that it may be on Odyssey. I would imagine that
there's not a transcript. I'll let everyone know. I'm going to need to inquire of Judge Reeder's court reporter as to how quickly she might be able to put the transcript together. I'm going to want to hear from the Jacksons today as well, but it may be that I need to look at that. One does not exist now. I'm sure it was taken down, but that takedown has not been turned into a transcript. So there's not a document for any of us to consult that would shed some light on the back and forth that may have happened between Ms. Love and Mr. Hawkins, and then as Mr. Hawkins has described it, really Judge Reeder being in the mix, which is appropriate during a plea hearing as to what a reasonable outcome in the case is.
Yes. So just then, in summary, I think I've covered what you're, as much as I can help, Your Honor. The rest, I believe the Jacksons could fill in. That I called Mr. and Ms. Jackson as soon as I saw that there was this modification, and so I was told, they were not in favor of it. The state generally would not be in favor of the ending of probation this early on. I mean, we're not even 2 years into a 5-year probated sentence. This is one of the earliest early termination petitions I've ever encountered. And for that reason, especially on a non-negotiated plea, I know the defense motion said it was negotiated. I would be surprised if that is the case in the plea transcript.
Well, and it's not the final disposition indicates it was a non-negotiated plea. And I heard Mr. Hopkins say pretty clearly, his recollection was there was some back and forth, so.
Okay. So just given the public, trust in equal justice and just in that a sentence is a sentence and my conversations with the Jacksons that led me to oppose this.
Okay. Ms. Rolak has something I think that she's going to share on behalf of the Jacksons, which is great. And I look forward to hearing that. I'm also happy to hear directly from either Ms. or Mr. Jackson. Before we pivot in that way, I had one other question for Ms. Goodfellow that I forgot to ask. Ms. Goodfellow, your lawyer did submit proof of completion of community service, but all it tells me is super small print, so I may be missing something, is that you did 500 hours. I'm interested in knowing where you did those hours. The final disposition was pretty clear that you needed to do it at one of 4 programs. And I'm curious which one or ones you selected and why. So
Montgomery County, which is the county that I am under the supervision of, does not, one, recognize they only have specific programs to work on. And my probation officer encouraged me to try to contact a couple of the ones listed would not take somebody under a felon, pending felony conviction. So I did my service at the Montgomery County Food Bank, the Montgomery County Salvation Army, the Montgomery County ASPCA were the 3 Food Bank, ASPCA, Salvation Army were the 3 where I contributed, did my time.
Okay, and so you would volunteer, provide services at one of those places, they document it, and ultimately those hours tallied up to the 500 that your probation.
Right. Montgomery County has an agreement with those agencies, and there are specific tasks and activities that you are allowed to do. For example, at the food service, you're not allowed to package food, but you're allowed to assist in the warehouse, do janitorial work. At the county animal shelter, it is primarily cleaning cages, feeding the animals, washing the dirty laundry, that type of thing. So there's specific activities that they allow you to do in community service. And there's a limited number of agencies that Montgomery County contracts with.
Okay.
And the agency itself tracks your hours. It's not personal tracking. They submit the hours worked into the probation office.
Okay. So you've paid your fine, you've completed your hours. What does being on probation entail for you now? What are the requirements for you?
Monthly reporting with my probation officer, random drug and alcohol testing, and then obviously continued compliance reporting with my employer or any future employer.
But that latter one is something that is an employment requirement, not a probation requirement.
Correct. I'm sorry.
If you worked at a gas station, you might not have to submit something to the SEC.
Correct.
Okay.
Correct.
And your monthly reporting, can you do that over the phone, or do you have to get in your car and go down to Probation Central?
Well, I'm not currently driving. That's
Bad example. Do you have to get on a bus and go down to Probation Central?
Normally, my husband is available to drive me.
But you have to report there in person. It's not a Zoom or a phone call.
No, it's been, it is actually a phone call this month because of the increase in COVID. It's been a little off and on, quite honestly, the past 9 months, whether it's in person or a phone call, because
Okay.
we don't know what COVID's doing here.
Got it. Thank you. Ms. Rolak, please share with me what you have.
Good morning, Judge. While the statement is somewhat lengthy, I wanted to read it in its entirety as I wanted to make sure that the victim's voice was heard by the court. This was written by Ms. Elizabeth Jackson on behalf of herself and Ronald Jackson. I am a retired school principal. One of the lessons I model is that our actions and consequences, some intended and some intended. My husband and I were in a crosswalk of an intersection with a traffic light, as well as the lights for pedestrian cross. We were walking in compliance with the indicated lights, and this was witnessed by a police who was at the intersection. I looked to my left as we were about 1/3 of the way across the street and saw the grill of Miss Goodfellow's Lincoln that was headed for my husband and me. My words were, "They're not stopping." My husband, Ron, was knocked down the street and Miss Goodfellow's car stopped with one of the tires on my left arm. She never intended to hit anyone, but her actions in the way she was driving resulted in injuries to two innocent people, Ron and me, that have lasting consequences for us. For us, the consequences of Miss Goodfellow's actions and of the timing of us being in the crosswalk began with my arm being degloved as the police backed the car off of my arm. My husband couldn't walk due to tendon damage he suffered. In addition to the injury to my left arm, the back of my head hit the pavement and created a gash across my head. This happened on June 16, 2016. Consequences of Ms. Goodfellow's actions after the initial hit include surgery to reattach the skin on my left arm and to set 2 broken bones in my arm. I spent 4 days in the hospital. I'm fortunate that this was my first hospitalization as for any reason other than childbirth. Staples in the back of my head to suture the gash. I had vertigo from my head injury for 9 months. I still have to comb my hair to cover the bald spot in the back of where my head was injured. I spent 13 months in physical therapy to regain the use of my left hand and arm. I had retired in June of 2015 and had begun volunteering significantly in nonprofit organizations in North Fulton. My time of volunteering for community service was put on hold as I focused on getting my fingers, hand, and arm to work. I required assistance with bathing and dressing for several months. I lost the opportunity to continue to serve on boards, to volunteer at agencies, and to accept interim jobs in the school system during my recovery from being hit by Miss Goodfellow. My injuries affected what I could do with my grandchildren. My grands still know to avoid my hurt arm. A section of my radial nerve in my left lower arm has a gap in it that is not expected to grow back. Due to this, I take medication daily for nerve pain. I have been on this medication since July of 2016, and I incur co-payments every time this medication is filled. I cannot wear a watch or bracelet or dress, sweater, or coat sleeves that fit around my left wrist due to the nerve damage. The sensitivity is like needles or bee stings, and it occurs some at night when the sheets and blankets lay against my wrist. I sleep with my left on top of the covers to stop the stinging sensation when this happens. I do not drive, nor do I ride with anyone who rode through the intersection that Miss Goodfellow drove on June 16th. This intersection is less than 5 miles from my home and is one that I have had to learn to go through, but never in the route used when I was hit. I never crossed the street in the intersection as we did on June 16, 2016. PTSD, flashbacks from being hit, continue to randomly happen. Ron spent several weeks with his foot in a boot, but he has recovered. He's careful about the shoes he wears, but his lasting scars are the purple coloring on his leg where he suffered the injury. During the plea, Judge was very thoughtful and deliberate with the consequences she assigned to Ms. Goodfellow for her actions, and these consequences should not be reduced significantly. During that last court hearing, Judge Reeder paused the proceedings for a brief period in order to call contacts she had in Texas to select several legitimate nonprofit organizations for Ms. Goodfellow's community service. When Ms. Goodfellow asked the judge if she could do all 500 community service hours in 1 year, the judge said she would not prohibit it. However, the judge went on to say that her intent and hope was that Ms. Goodfellow would do 100 hours of service per year for 5 years, and that Ms. Goodfellow would develop a relationship and continue to volunteer with the agency beyond the time of her probation. I understand that Ms. Goodfellow did do and as quickly as possible completed her 500 hours of community service in the first 20 months of her 60-month probation for her 2 felonies. However, I do not believe that it is appropriate to terminate Ms. Goodfellow's probation. She has served 1/3 of the time the judge assigned. I'm thankful alive, but I lost a year of my life to physical and emotional injuries caused by Ms. Goodfellow. It has taken me years to resume activities, and as I've stated, I do so with limitations and lifelong consequences from Ms. Goodfellow's actions. I was crossing the street in the way I was supposed to do it, but I will live with my consequences from being hit by a large Lincoln accelerating through a pedestrian crossing for the rest of my life. I believe it's too early to terminate Ms. Goodfellow's position. Thank you respectfully, Liz Jackson.
Thank you, Ms. Rolak, and thank you, Ms. Jackson, for putting those words onto paper. It's often easier for victims to take the time to choose their words and compose something in writing, and then Ms. Rolak does a very good job of presenting that. And it's helped me understand the impact that this incident has had on both of you. So it provides some very meaningful context. I appreciate that. Ms. Jackson, is there anything you want to add beyond what Ms. Rolak shared? You're certainly not limited to what she shared, but that was also, I find, very sufficient.
Okay, I think I'm unmuted.
Yes.
Okay, good. Yes, I thank you so much, Ms. Rolak, for reading our statement. And Your Honor, thank you so much for asking for any further input. I will reiterate, as Mr. Hawkins has presented, we did not favor jail sentence. We did not feel that that would be beneficial to Ms. Goodfellow nor to anyone else. So at the trial, we opposed the jail sentence. However, we did favor a reasonable amount of community service, a reasonable amount time limit on a probation. I honestly oppose an early termination at this point with 1/3 of the service being given. And I don't want to be a vindictive and hateful person.
And you don't sound that way. I want to be clear. You don't need to sound defensive. You are expressing heartfelt and understandable feelings right now. So you shouldn't worry about that.
Okay. And, you know, I have kids. We have taught actions have consequences. You accept the responsibility for that. So that's all the main thing I have to say is the intent of the community service was to try to develop a habit. And that I appreciated Judge Reeder in trying to set that in motion by all that she did to check it and to try to send it, set it up that way. But that's my position.
Okay. Mr. Jackson, anything you want to add?
Yes, Your Honor, I would like to share just a few thoughts. The impact Liz has shared in her written statement, the impact that this has had on us. She's come a long way. The PTSD from this has been pretty profound. The first time we went to church after this happened, we parked on one side of the street and crossed. And when I got to the other side of the street, I realized she was crying. And it was because she had to cross the street. And it was down the street from where we were hit, but it was the same street. And we had a police officer in the crosswalk helping us across, but it's still very traumatic for her. I don't believe Mrs. Goodfellow is a habitual hitter of people in crosswalks. The other side of the coin is, as Liz pointed out, there are consequences for actions. And I think she was careless and very selfish. So the probation, the community service, as I understood it, there was also a driver's license piece, and that hadn't been mentioned this morning at all.
Well, I'm going to ask about that. And it was actually indirectly mentioned because when I was trying to figure out what Ms. Goodfellow needs to do for probation, I said, well, do you drive down to probation? She said, actually, I don't drive right now. So I'm going to circle back with her about that because in big, bold letters on the sentence, it says license suspended for 3 years. It says as operation of law, but I'm going to want to understand that a little bit more from Mr. Hawkins and Ms. Goodfellow, but I don't think she was concealing that from
Right,
me.
I understand that. But my point was that the community service is important. It's important because, in my view, the community service does more for the person doing the service than it may do for the nonprofit. It makes them a better person. It makes me feel better when I do it. The driver's license piece was very important to me. I understand there's a compact in our country in the United States between almost every state in the union that when this kind of felony takes place, the license is automatically suspended. So that is important to me that if anything else, that remain intact. Mr. Hawkins, in his summary of what occurred, mentioned specifically, said no alcohol, no drugs. She was field tested by Officer Bryant, who happened to be in the intersection when we were hit. He saw it. And he is an expert in Roswell on DUIs. He field tested her, and he found that of the 6 field tests, she failed 2. And so, as I understand it, the plea that she agreed to had something to do with alcohol, DUI, whatever. So I guess in sum, my concern is the original prosecutor, ADA, Ms. Love, mentioned 5 years, served 2. Liz and I don't want that to happen. Ms. Goodfellow is not a habitual hitter. On the other hand, there are consequences. And Liz and I will live with consequences the rest of our lives. Liz takes nerve stuff for her arm every day because it's damaged and will continue to be damaged. So we have consequences. This needs to be treated because it is a very serious situation. The sanctions, the consequences need to be serious as well. So that's what I would tell you. Thank you, Your Honor.
Thank you, sir. I appreciate you sharing that. Mr. Hawkins, before you provide any summary response to what you've heard, let's talk a little bit about the license suspension. As I mentioned, the final disposition, it's in a place where I've not seen language before. It's above the box that lists what the specific sentence is, but in large font, it says license suspended for 3 years as operation of law. you are the subject matter expert in this area of the law. So my first question is, from what date is that suspension measured?
The date of suspension is measured from the date of the plea.
Okay, not the date of the incident, but the date of the plea.
That's correct, Your Honor. And
Okay.
the language by operation of law, there are certain offenses under Georgia's statutory scheme that actually don't require written notice. DUI, felony vehicular homicide, misdemeanor and felony vehicular homicide,
Yep.
and serious injury by vehicle.
Okay, so by operation of law, like some statutes, there's a mandatory fine, but a conviction for serious injury by vehicle, OCGA 40-6-394, that has, by operation of law, the consequence, regardless of your sentence, a 3-year license suspension.
Yeah, and so I guess the way that I've always looked at it, Judge, is that if you are sentenced for any of those offenses that state by operation of law, that is notice of the suspension and it begins on that date.
Okay. What is your understanding as to its portability? Mr. Jackson was referring to compacts that exist between states, and some states get along and some don't, and some say you can bring your guns into our state and others say you can't. What's life for Ms. Goodfellow in Texas as a result of this?
So I'm impressed with Mr. Jackson's knowledge of that. Very few people are aware of that. There are actually 3 compacts. Georgia participates in 2 of the 3. One of them, the best way I can describe it, is that when a person renews their license, they do a sweep of any other state's computers to see if there's any action taken against it. My understanding is that Texas recognizes Georgia's suspensions. And if you heard Ms. Goodfellow describing earlier, she does not drive. She relies upon her husband to get her where she needs to go. And I want to say this directly to Mr. and Mrs. Jackson and to the court. Early termination of the sentence has no bearing on the suspension. It will remain under suspension for 3 years from the date of the plea.
That was my next question. So you predicted it and you answered it.
Yeah. So, and I've seen that before in a variety of circumstances, even where the sentence itself. So Judge, the sentence is considered the criminal penalty. The license suspension is an administrative or civil action against the person's driver's license or privilege to drive on the highways of the state.
Okay.
So hopefully that answers your inquiry.
It does. Ms. Goodfellow, have you and your probation officer or you and anyone from Texas DMV discussed suspension and when you might be able to get your license back?
Only at our onboarding meeting, my initial meeting with Ms. Rankin, my probation officer, and she went through the terms and conditions of my probation, and that included not driving. And so that is listed on my monthly report forms as a special condition, suspended license.
Well, does Ms. Rankin have a view that she shared with you as to how long your license is suspended? Does she view it as being as long as your sentence is, or Mr. Hawkins has helped me understand that they really are independent. I could end your sentence today, and according to Mr. Hawkins, your driver's license suspension would continue through April of 2022. That would be 3 years from your plea. Your probation, in theory, will run longer than that, but I guess I'm confused by the way you put it. Because it's not really a condition of your probation.
Right. I have not specifically asked her that question. So she has followed the letter of the judgment from Georgia to the best of what Montgomery County allows. So I would assume that it is the 3 years, but I have never specifically discussed that with her. Because I honestly wasn't thinking of the disconnect between the suspension and eliminating the probation requirements when I approached Mike about this motion.
Okay, that's not a problem. It's helpful for me to learn. All right, Mr. Hawkins, anything you want to close out with?
If I may, Judge.
You may.
And just a couple of comments. I've been doing my best to take notes along the way. Again, I'll ask the court just to go back in passing upon this motion and apply the legal standard that the legislature has set in this instance, is that if the court determines probation is no longer necessary or appropriate for the ends of justice, the protection of society, and the rehabilitation of the defendant, the court is authorized to early terminate. I certainly appreciate and respect the input from the Jacksons, and I hope that they will continue to progress in their healing, both emotionally and physically. Mr. Pinion did indicate, and I agree with him, this is one of the earliest petitions for early termination. And I think, Judge, that is a function of what I mentioned earlier. I don't know of any defendant, and I've been practicing law for 29 years, my first 5 as a prosecutor. I haven't seen a defendant as a prosecutor. I haven't represented a defendant who has done more in such a rapid amount of time to immediately address the sentence conditions. And so I think he's right about that. And I think when Mr. and Mrs. Jackson talk about for actions there are consequences, I don't hesitate for a moment in representing to the court that Miss Goodfellow takes into account their injuries. She is extremely remorseful, has been throughout. Bear in mind, Judge, that this case took 3 years to be resolved in court. And, you know, this is an incident that happened in June 2016. So we're going on 4.5 years approximately. I would like to think that part of actions having consequences is that one of the consequences of a defendant who made a terrible mistake and caused such serious injuries as Ms. Goodfellow did is that the steps that she's taken to demonstrate her remorse, her rehabilitation, the immediate action that she's taken, the substantial steps that she's taken to complete these terms of her sentence in an expedited manner. I would like to think that that's part of also all of us recognizing that perhaps those actions might have some positive consequences for Ms. Goodfellow. In hearing from the Jacksons, I certainly appreciate Mr. Jackson indicating what was important to him. I mean, Ms. Goodfellow will forever be grateful to the Jacksons for their forgiveness, for their understanding, and for them advocating for what they thought was appropriate. And we certainly understand their position on this now. But this is a situation, Judge, where rather than looking at the underlying facts of what took place, we're here to address whether the continuation of Ms. Goodfellow's probation sentence is necessary to meet the ends of justice, necessary to protect society, and necessary to rehabilitate the defendant. I would say I'll address the last two very quickly. I don't think there can be any argument made that there's any further need for the protection of society. And Mr. Jackson and Ms. Jackson indicated they're not of the belief, although they are personally scarred by this, they hesitate on their way to church and crossing a crosswalk. That's certainly understandable. They don't harbor the think that there's any evidence that she is a risk of reoffending. So the protection of society in furthering the sentence, I think, is very limited. And I would say the same about the rehabilitation of the defendant, Judge. She has completed all these hours of community service where she was directed to by probation in Montgomery County. With your permission, Judge, I neglected to mention, with your permission, I'd like, if you give Ms. Goodfellow the opportunity to share with you one of the reasons that she wants to continue doing community service. She is something I am not, and that is an expert at math. I will share that I went to law school because my brain does not do math well. She has engaged in the past in tutoring students in mathematics. She is prevented from doing that because she is under court sentence. And that is the extent of what I know about this that she and I have discussed. If you're willing to hear from her, I think it would be beneficial for the court to hear, and perhaps for Mr. and Mrs. Jackson to hear her desire to continue to give back to society for her mistake is being limited. And she has some expertise that many of us don't have to be able to make a difference in young people's lives, that being under court sentence is going to continue to prevent her from doing that. And community service is important. As the Jacksons say, it's important to her. And, you know, she could continue to go to the food bank. She could continue to do the other things that she's doing. But I would like to think that where an individual has unique gifts to offer, that we would want to take advantage of those and consider that, and for you to consider that, Judge, in early termination. I am encouraged, Your Honor, by your recognizing that you're going to go back and read the transcript of this. I think that will be helpful to the court, and I'm glad to hear that you're going to do that. It is not clear to me, Judge, because I don't have a transcript as well. I do have a memory, and I hope it was on the record, of there being a discussion about the judge wanting 100 hours of community service every year for 5 years, but Judge Reeder recognizing that that is a significant amount of community service for any individual who's working full-time and is the breadwinner for the family. And again, without at the risk of repeating myself, I frankly think it's remarkable and unprecedented in my experience, the amount of community service she's completed up front. And I would like to think that those actions would have some positive consequences for Ms. Goodfellow. And essentially, Judge, that's my summary. You have the documentation. You've heard what our request is on behalf of the court. I do appreciate the statement Ms. Rolak read, and that was provided by Mr. and Mrs. Jackson, their statements here today. And I would ask you to take all these things into account and recognize that the best possible thing for everyone here, including society, is to allow Ms. Goodfellow to conclude her probation early. And she will remain under suspension for 3 years. That is my understanding of the law. But she will be allowed to keep her job. I think she said the review is coming up at the end of March for her company, which has been hit hard, as many commercial real estate outfits have been hit hard during the pandemic. And continue to support her husband and her disabled son in his endeavors to complete a college degree. So I'd ask you to consider all those things. And just briefly, Judge, if you would hear from Ms. Goodfellow, I neglected in part of my presentation to ask her about her tutoring and her community service there.
Thank you, Mr. Hawkins. Ms. Goodfellow, I think I understand what it is you used to do and what it is you'd like to do in terms of tutoring. Is there something you want to add to that?
I would just add that, and I can only go by the area I live. Our high school students in particular have been impacted by distance learning, and particularly those students in higher level AP math, calculus, that type of class. And there is a need in our area for assistance, which I am able to provide, but am currently prohibited by being on probation. And in support of what the Jacksons had said, I took to heart what the judge said about service. And I don't know if it's right to say I enjoyed many of the things I did. And I would like to contribute in areas where there is a need, such as, helping kids that are now lagging. And I've talked to a neighbor who's in the school district, and, but this is the obstacle, and I apologize for not mentioning that earlier.
That's okay. But help me understand, is it the case that this is something you'd like to do, or it's something that you used to do and you've had to pause and you'd like to resume?
Over the years, and I'm old, I'm 62. Over the years, I have engaged in tutoring, mentoring, and assisting high school, college, and I hold a CFA, and also assisting, candidates in that program.
Okay. All right. Well, I appreciate you sharing that. I appreciate everyone's contributions here. You have done a great job of giving me a clearer picture of what this case is about and what the Jacksons have gone through, which is tragic, and where Ms. Goodfellow finds herself now. And I appreciate hearing all that. I'm going to need a few things before I can sort this out. I'll take care of one of them, and that will be getting a transcript, and I'll make sure that the transcript is filed and made of record. So I'm not the only one who reads it, but I will reach out to the court reporter who likely, well, I know who took it down because her name is on the final disposition. So I'll reach out to Ms. Touros and figure out when we can get the transcript. And then that will be filed. Everyone can see it. And then, Mr. Hawkins, I need you and your client to get something for me. You'll need to share it with Mr. Pinion as well. And it comes from Ms. Rankin. It will come from Ms. Rankin, who, as I understand it, is Ms. Goodfellow's probation officer. I would like to get from Ms. Rankin a brief review of how Ms. Goodfellow has done on probation, Ms. Rankin's view as to Ms. Goodfellow's suitability for early termination. It's number 2. And then number 3, Ms. Rankin's understanding of how probation and the driver's license suspension are intertwined. In other words, does Ms. Rankin think that the suspension ends if probation ends, and that it runs as long as probation runs? And I appreciate Ms. Rankin is not the lawyer in the mix, but she hopefully has some insight into this, having dealt with other probationers who've had their driver's license suspended. But I'm wanting to make sure that the system in Montgomery County won't think that if probation ends early, whether that's now or in 6 months or a year, that is not a signal that the suspension should end early, unless that's what the law is in Texas, and the way in which they participate in the compact is the suspension will run at maximum of 3 years, but it will end early if probation ends early. I don't know the answer to that. And Mr. Hawkins, I know you practice in this area, but you're a Georgia lawyer, not a Texas one. So it would be good to get some input from the Texas side of things. Does that make sense? I want to make my inquiry as clear as possible, because you and Ms. Goodfellow will need to actually propound those questions to Ms. Rankin and her team.
Judge, if I just may review, you want a review of her status and accomplishments as a probationer, 2 is her suitability for early termination, and 3, input on whether, if probation ends early, what her understanding is if the license suspension will end early.
Correct. And as to the first one, I know Ms. Goodfellow's accomplishments. She's paid her fine, she's done her community service, but it would be helpful to hear from Ms. Rankin. Ms. Rankin may say she's done that, but she's a complete pain and she is high maintenance, et cetera. And that's a different portrait than what's been painted. I have a sneaking suspicion that's not what Ms. Rankin's going to say. But what I often see accompanying a request like this is input from the officer or officers who've been doing the supervising, saying, client X has been real easy to work with, is compliant. They use the words they use, but it helps me get a different perspective on the scenario. Okay. I understand why, Mr. Hawkins, you're saying good things about Ms. Goodfellow, and it would be good to hear from Ms. Rankin.
Okay.
All right. I'll work on a transcript, and Mr. Hawkins, you and Ms. Goodfellow work on the information from Ms. Rankin, and as you get it, please share it with Ms. Nelson, my litigation manager, and with Mr. Pinion, so that everyone who needs to see it is getting it.
Will do, Your Honor.
Mr. Pinion, anything else from the state?
Nothing further. I just the state's position is still that the ends of justice would not be served by an early termination this early, and so nothing beyond that, Your Honor. And thank you.
I appreciate that. That's been your consistent position, and that's what the Jacksons have articulated very clearly to me as well. And I understand that perspective as well. That's why we're having the hearing, because there are competing perspectives, all of which are understandable. Well, thank you everyone for your time. Happy New Year. May 2021 be better for you than 2020 was. I will be back in touch when I know more about when we can get a transcript of the plea hearing.
Thank you, Your Honor.
Thanks.
Thank you.